Hello, NMAR members. I'm Ashley Strauss-Martin, General Counsel for the New Mexico Association of Realtors. 4 revised NMAR forms will be available in the Incident Library on or about September 20th. In this video, I'll discuss changes to one of those forms, the Backup Purchase Agreement, Form 1530. This is part 2 in a 3-part series that covers all 4 forms, so be sure to watch the others when you can. Also, for purposes of this video, I will sometimes refer to the Backup Purchase Agreement as the Backup Contract. The Backup Purchase Agreement Form 1530 is currently designed for one backup contract, not multiple backup contracts. But in a seller's market, there may be multiple buyers willing to enter into backup contract, and Form 1530 has been redesigned to accommodate the situation. First, remember that it will be the buyer who is completing this form, but it will be imperative that the buyer's broker and listing broker communicate about how many offers the seller has accepted before the buyer completes this form. In paragraph 1, the buyer indicates if seller has already accepted only one other offer, referred to as the primary purchase agreement, or if the seller has accepted other backup contracts, referred to as prior backup contracts. Also, the contingency is created in paragraph 1. The contingency is this: neither buyer nor seller are obligated to perform on this backup contract unless and until all prior offers accepted by the seller have terminated. Note that whether a prior offer has terminated is completely left to the seller's discretion. Also note that in this paragraph 1, it is not necessary to indicate how many backup contracts the seller has signed. We'll get into that in a minute. For now, you only need to know if there are any backup contracts ahead of your buyer's contract. In paragraph 2, seller agrees to notify buyer immediately of the termination of the primary purchase agreement and any prior backup purchase agreements. We'll see the notification provisions on page 2 in a minute. Remember, this backup purchase agreement does not become the primary purchase agreement until and unless the seller has notified buyer that the primary purchase agreement and all prior backup purchase agreements have terminated. This is also the paragraph where the parties get to decide how long they want to be obligated under this backup purchase contract. Now listen, you buyers brokers, this is important. If the seller accepts this backup contract, both the buyer and seller are obligated under this backup contract until this date. I know buyers often think that they can put in a backup contract, keep looking at other houses, and if they see something they like better, they can then terminate this backup contract by simply notifying the seller. This is simply not the case. This is a contract, and under this contract, the seller is obligated to move the buyer into first position if the prior contracts terminate, and buyer is obligated to wait until the date in this paragraph before they can walk away. See, it's a two-way street. So if you have a buyer who loves the house, can't imagine themselves living anywhere else, this date is going to be set way into the future because this buyer wants this house and they're in it for the long haul. But if you have a buyer who wants to keep looking and wants the ability to walk away next week if they find something else they like, then this date will be set a very short time from now, so as not to tie up the buyer for too long. Of course, the key for you buyers brokers is communication with your buyer when setting this date. The other important language to note in paragraph 2 is this: seller shall move backup purchase agreements into primary position in the order in which they were accepted by the seller. This means that if the primary purchase agreement terminates, buyer must move backup contract 1 into primary position before moving backup contract 2 into primary position. And seller must do this even if backup contract 2 is a better backup contract for the seller than backup 1. Paragraph 3 ties into the paragraph 2 date. It explains that we have a contract once this backup contract is fully executed and delivered, which means the parties are under contract as of the date of acceptance and must hang in there until the date in paragraph 2, unless the parties agree otherwise. However, the parties are not obligated to perform on this backup purchase agreement until the time frame set forth in paragraph 4. Paragraph 4 is entitled Time Frame for Performance. This explains when the parties, the buyer and the seller, must start performing on this contract. No buyer is going to want to start spending money on inspections and surveys and appraisals, etc., when they don't know when or if they will ever be the primary purchase agreement. Again, that's why neither party is obligated to perform on this backup contract until and unless the buyer receives written notification from the seller that the primary purchase agreement and all prior purchase agreements have terminated. This paragraph 4 means that where a date for performance in the backup purchase agreement states X number of days from date of acceptance, the date for performance shall be X number of days from the date that seller notifies buyer that buyer's backup purchase agreement is now the primary purchase agreement. Now, we don't know when or if this buyer will move into primary position, so we note that there should not be any specific calendar date deadlines, such as March 1st, in this backup purchase agreement. All dates in the backup purchase agreement should be expressed in a number of days, such as 4 days. So again, the purchase agreement will say, for example, the earnest money is due 3 days from date of acceptance. But with this addendum, that will now mean earnest money is due 3 days from the date the buyer is notified he is moved into primary position. Paragraph 5 addresses notification to the buyer that the prior purchase agreement has terminated. When notifying the buyer that a prior backup contract has terminated, the seller may deliver notice via email, text, hand delivery, or any other way the parties have agreed upon in this paragraph. But when notifying the buyer that the primary purchase agreement has terminated and that buyer is now the primary purchase agreement, the notification is more formal. And why would that be? Well, remember paragraph 4, timeframes for performance. This date, the date the seller notifies buyer that buyer's purchase agreement is the primary purchase agreement, is the date the buyer must start performing on that purchase agreement. Tick-tock, the clock has started. So at the bottom of page 2, there is a place for seller to sign that tells buyer your purchase agreement is now the primary purchase agreement. Now we've come to the end of the form, but before buyer and seller sign this backup contract addendum, there's a very important box that the buyer must complete and the seller must review. The language in the box says, by signature hereto, seller affirms this backup purchase agreement is backup purchase agreement number, and there's a blank line for buyer to complete. And in the box, there are some directions to the parties as to how to handle this blank space. First, it says, this section is to be completed by buyer. This ties back into what I said at the beginning of this video. The buyer's broker must communicate with the listing broker to identify the backup position for this buyer. I had a broker make a comment that the buyer will not know what backup position he or she is in when completing this form, but such information is surely relevant to the buyer, right? As a buyer, I want to know, am I the first backup contract or the 10th backup contract? So again, it's imperative that the buyer's broker ascertain this information from the listing broker before writing this backup contract. The language in the box then says that seller must review for accuracy before signing this addendum. If the number is incorrect, seller should not sign this addendum. Seller may submit a counteroffer with the correct number and or notify the buyer's broker of the correct number so that the buyer may submit a corrected backup purchase agreement addendum. So listing brokers, you need to be paying attention here. You need to be reviewing for accuracy the number that the buyer's broker has put in this blank. Lastly, the language in the box explains that for purposes of determining this number, only count the number of prior backup purchase agreements the seller has accepted. Do not count the primary purchase agreement. And it gives an example. If buyer is the first backup purchase agreement behind the primary purchase agreement, then this is backup purchase agreement number 1. If seller has already entered into one backup purchase agreement before this one, then this is backup purchase agreement number 2, and so on and so forth. And that is the new and improved backup purchase agreement. If you have questions about this form or any NMAR form, please contact me on the NMAR Legal Hotline. This concludes part 2 of the 3-part series. Be sure to watch part 1, in which I covered an addition to the exclusive right to sell listing agreement and the new amendment addendum, and part 3, in which I cover the seller's notification of multiple offers, the form that will replace the invitation to offer. Thank you and have a great day.